Is a New York law that allows universal mail-in voting without the need for an excuse constitutional? To find out, you have to read Stefanik versus Hochul, but it's 89 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Stefanik versus Hochul. The citation for this case is 2024 New York Slip Opinion 04236, published by the New York Court of Appeals on June 20th of 2024. The issue in this case is whether New York's new law authorizing universal mail-in voting without needing to give an excuse is constitutional or not. To understand and appreciate the context of this case, I think the background that's helpful to know is that there's a very long history, 200 years of constitutional amendments relating to the ability to vote in New York. Under New York's Constitution, Article 2, Section 1, it states that every citizen shall be entitled to vote at every election. Okay, that's the important word, at every election. Under New York's Constitution, Article 2, Section 2, it talks about authorizing absentee voting. And under that section, it states that the legislature may, by general law, provide a manner in which qualified voters can vote who may be unable to appear personally at the polling place because of illness or physical disability, and who may vote and for the return and canvass of their votes. So Section 2 of Article 2 talks about absentee voting in those terms. And lastly, Article 2, Section 7 of the New York State Constitution says that all elections by citizens can be controlled and governed by the legislature by such method as are prescribed by law. It gives the legislature the ability to prescribe the method of conducting elections. What are the facts in this case? The facts are that although there's couple hundred years of constitutional amendments and laws about voting, every once in a while there's constitutional amendments that are presented to the people at elections and ballots. And in 2019 and 2021, the legislature passed a proposed constitutional amendment that was put to the voters in 2021, which would allow universal absentee voting. With the explanation given, the legislature has to give a little explanation as to why they're presenting this constitutional amendment proposal. And the explanation that the legislature arrived at was that voting by mail requires constitutional amendment because the New York Constitution only allows absentee voting if a person expects to be absent from the county in which they live or because of illness or physical disability. That's the legislative explanation for this constitutional amendment. It failed. The public voted it down, 55 to 45. It was resoundingly defeated by the people, by the voters in a constitutional referenda. Nevertheless, in September of 2023, the New York legislature passed the instant legislation, which is Universal Early Mail Voter Act, permitting any registered voter to vote early by mail. The legislation indicated that this was early voting by mail is different from absentee voting. How they justified doing this was they said it's not the same thing as absentee voting. We're just changing the way which people vote. Effective January 1st of 2024. The plaintiff sued claiming that it violates Article 2, Section 2 of the New York Constitution. The defense opposed, saying that it fails under the legislature's ability to govern and control the methods of voting under Article 2, Section 7. And when it goes to the Supreme Court, the procedural history here is that the trial court declared the act constitutional, dismissed the complaint, gets appealed to the appellate division. They affirmed what the Supreme Court had done, knowing that the legislature has the power to regulate elections under Article 2, Section 7, and nothing in the Constitution prohibits mail-in voting. It appeals to the Court of Appeals, and here what we have is 89 pages of 3 different decisions. The majority decision here is by 4 judges. There's a concurrence by Judge Rivera and Judge Troutman, and then there's Judge Garcia alone in dissent. The majority decision here, 4 judges say, it's constitutional. Why? 3 reasons. There's a strong presumption that anything that any legislation that the legislature passes is constitutional. There's a presumption of constitutionality. Number 2, the legislature's power to pass legislation is plenary, meaning they could do anything, with the exception that limited only by federal and state constitutions. They could do anything in the whole world that a legislature could do unless it's prohibited by a constitution of the federal government or the state government. So the question here is not whether the Constitution permits voting by mail, but whether it prohibits voting by mail. That's how the majority approaches this. And their ultimate answer here is that nothing in the Constitution has ever definitively prohibited voting by mail. And because the legislature has the authority to regulate the methods of voting, they can do this. This is different than absentee voting, which requires a reason why you can't vote on the normal way. This is just changing the way that you vote. Importantly, the majority says that the word "at" with respect to every citizen shall be entitled to vote at every election is not location-based. It is it carries the same meaning as the word "in," that every citizen shall be entitled to vote in every election. It's not location-based, it's sort of temporal-based. It's the concept of elections. So they say there's nothing that's ever prohibited universal mail voting, and so it's not prohibited right now. The concurrence by Judge Rivera and Judge Troutman disagrees to some extent. They agree it's constitutional, but they say there was something in the Constitution for a period of time from 1821 till 1966. There was the election district provision, which did require voting in person, but that was removed in 1966. So nothing currently in the Constitution prohibits universal mail-in voting. And lastly, Judge Garcia says that it's unconstitutional because the Constitution presumes that everything should be in person. And he relies upon, Judge Garcia, that is, relies upon the maxim of expressio unius est exclusio alterius, which is a statutory interpretation technique where basically you say if a statute allows something only in circumstances of A, B, and C, then it intentionally excludes everything else. So you can, if a statute specifically gives ways in which something else can be done, then everything else is excluded except for the ways that are specifically stated. And here he says, the Constitution says you can vote absentee if you're ill, if you're out of the jurisdiction for certain reasons, and because there's certain reasons given, every other reason is not appropriate under that maxim of expressio unius est exclusio alterius, the Latin maxim. So he would say it's unconstitutional, but 6 of the judges say it is constitutional, and that's the case of Stefanik versus Hochul. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.